Okay, this is People of the State of Michigan versus Terrence Brown, docket number 20-70FH. And this is the time set for sentencing. Mr. Brown, can you just confirm for me that you're okay with doing this with you being remote, not in the courtroom?
Yes, Your Honor.
Yes, okay, thank you. So, Mr. Brown, you were convicted of possession of less than 25 grams of cocaine. That is a felony punishable by up to 4 years in prison. You have the right to be represented by an attorney. You are represented by Mr. Silverthorne, who's present with you. And Mr. Silverthorne, have you had a chance to go through the pre-sentence report with your client?
I have, Your Honor. I would indicate, I think Mr. Martin would agree that there is a matter that we have to discuss at some point that just came up.
Okay, who's got the horrible audio feedback?
Mr., if you mute, sir, if you mute.
He is muted.
My sound is probably loud enough that you can hear.
Are you two on separate devices?
I'm sorry, are we on separate?
Yes.
Devices.
Yes.
Well, he should mute his device as well.
Yeah, mute
He
your
must
device so that it doesn't receive sound.
He must be close enough to you that he's picking, that
Yeah.
you're picking them up on your device as well,
Well,
right?
yes, exactly.
Yeah, that's the problem. So he needs to mute whatever device he's on. Okay. So the issue that you raised, Mr. Silverthorne, is it a correction to the report?
No, it's an interpretation of the Killebrew agreement was no upfront jail and no objective 7411 status. As I explained to Mr. Martin, we don't get complete records. For my chat, we only get adult records. And so I wasn't aware of a 1997 juvenile court adjudication on a drug charge. I was aware of a later marijuana charge, but often those marijuana charges are dealt with for first-time offenders where it doesn't result in one. Ms. Stout
Okay.
recommended 7411, and so I thought he was eligible. And only probably within the last 10 minutes when I saw Mr. Martin's email indicating that he didn't think he was eligible, that it became an issue. And I have a very upset Mr. Brown here who was almost as much as not getting jail was hoping to just not get a conviction because he knew he was going to complete probation successfully.
Okay, you're referring to number 9 of 10 in the pre-sentence report, is that correct?
That's correct, Your Honor. That's a juvenile court adjudication. When we get iChat, we don't have access to full lien. When we get the iChat, we don't get the juvenile record. We do get the marijuana conviction, but there's a provision in the law for first-time marijuana offenders to have it not result in a conviction, and we often see that we get those. So I wasn't aware until moments ago that when I was informed when I was looking through my hundreds of emails that Mr. Martin had gotten hold of me and that he didn't think he was eligible for 7411, and that's real. To do it at the last minute, I, as a longtime defense attorney, that's really not the way to do it.
If I may,
I'm not faulting Mr. Martin at all.
Well, yeah, I know, hold on. I'm just reading the statute to make sure.
oh, I see.
Okay, yeah, it appears that he isn't. Well, what do you propose?
Well, what I proposed to Mr. Martin, but I'll be honest, I haven't frankly researched it, is if he could do exactly the same probation with the same chances of success or failure, and if Mr. Martin would agree to a deferral based upon the completion and then have it dismissed, because it achieves basically the same thing. You know, I may be being overly clever and there may be a prohibition against it, I don't know. But I do know that if he does exactly the same probation and he winds up with a dismissal, that would have been the same thing he would have gotten under 7411.
Well, I don't know of any law that allows him to do the same probation and get a deferral and dismissal.
I don't either. I don't know what, I haven't researched, again, because this came up at the last moment, what offenses can be entered under advisement or under a deferred status.
I don't do, like,
I understand.
yeah.
Then the issue would be, do we consider the 7411 status with there being no opposition? Does that imply that there's eligibility such that he could withdraw his plea? Because that's where he's at right now, unless, and
Yeah,
I'm.
I mean, this is what I propose. I mean, to me, this is like worthy of being able to withdraw your plea. Maybe we should just reset this and if you two think you can work something out, then maybe it can be fixed, but via a plea agreement. But if it can't be fixed, then I think going into a plea agreement, agreeing that someone gets 7411, finding out, not knowing at the time and finding out later that they're not eligible is grounds for withdrawing a plea.
Thank you, Your Honor. I worked very well with Mr. Martin. I think that we can, with probably some time that we did not have because of the last minute nature of this, that something else can be worked out.
Okay.
But
then
time
we'll
is necessary.
Right. Then I'll just do this. I'll adjourn it without date, but I'm going to keep track of it so it doesn't slip through the cracks time-wise, and allow you two to see if you can work something out. Please let me know if you are able to do that, and if not, then I think you're going to have to just make some kind of a motion to withdraw the plea.
Okay, Your Honor.
All right. Thank you. Anything further?
No, Your
Nothing
Honor.
from the-
I hope this
Nothing from the
meeting-
people. Thank you, Your Honor.
Since it's so short.